Meeting is being recorded.
I would like to call the meeting to order for the Speech Language Pathology and Audiology and Hearing Aid Dispensers Board. This is Friday, August 13th, 2021, and the time is 9:01. We got through quite a bit of the agenda yesterday, so we're going to be starting at agenda item number 10 this morning. We'll start with the overview of the sunset review process and timeline, and I'd like to turn that discussion over to the Executive Officer, Paul Sanchez.
Good morning. Before we do that, do we need to call roll again?
Sorry, thank you. Gosh,
That's okay.
I'm awful. Okay, I would like to call roll. Holly Kaiser?
Here.
Todd Borges?
Here.
Karen Chang?
Here.
Gilda Dominguez?
Here.
Debbie Snow?
Here.
And I'm here, and that establishes a quorum for today's meeting.
Okay, and I think because we're starting a new day, I believe we'll also have to open up for public comment for items not on the agenda.
Yes. Can I call for public comment for items not on the agenda?
Good morning. This is the moderator. For public comment today, we will be utilizing the question and answer feature in WebEx. To access this, you will locate the Q&A icon on your screen, which is a question mark located inside of a square. When you click on that, it will open a text box. In that text box, you can simply type comment and then submit that to all panelists. We are working in a new WebEx environment today, same as yesterday, but in case you were not with us yesterday. For the public comment, when I do call on you to make your public comment, I will not be able to directly unmute your microphone. I will be sending you a request, which will allow you to unmute your own microphone. You'll receive a pop-up on your end of the screen, and you will simply click the unmute me button, and then that will open your microphone. I will caution that when you do that, the WebEx will play a brief statement, so you'll want to pause for just a moment to allow that statement to play before you start speaking. Otherwise, we won't be able to hear the beginning of your statement. Also, we have new closed captioning available through WebEx. You should see somewhere on your screen, typically at the bottom, live action captioning. You are able to turn that off if you don't want to see it. For most people, you can also click on it and move it around your screen if you'd like it to appear somewhere else. But if you would like to shut that off so that you don't have to see it on your screen, you can do so by locating the closed captioning icon. It's typically in the bottom left corner of your screen, should be associated with what looks like a little robot icon. If you hover over that closed captioning icon and click on it, you can hide that captioning. You can also repeat that procedure if you'd like to again see it. And with that, looks like we don't have any comments at this time. Would you like me to close the panel?
Yes, please.
It is closed.
Thank you. Okay, Paul, would you like to go ahead?
Yes. Good morning, board members. We're on agenda item A. We would like to provide you just a brief overview of our sunset review process and timeline. Some of you are newer board members or new board members and have not been through this process with the board. So we want to just go over it. Every year, the Assembly Business and Professions Committee and the Senate Business Professions and Economic Development Committees hold what is a joint sunset review oversight hearings to review the boards and bureaus under the Department of Consumer Affairs. For us, this is done every 4 years. We have in our statute a sunset date. That sunset date was initially set at 2022, but because of COVID, they got behind and had to make some adjustments. So our sunset was extended to 2023. This is a big process in our office where we are, a lot of our time is taken up to put up this report. What it starts out with is a questionnaire that comes to our board staff, and we work on the questionnaire. It's an extensive document that becomes a book. the sunset process itself is time for the committee to evaluate boards. It's actually a great process. It provides transparency to the public. It's not so great from the standpoint of having to work it. It's pretty grueling, and during this time, as we start getting busy, we put all of our energy and efforts into this to make sure that we're reporting everything and addressing any questions or concerns that might come up. So what this will look like is we get a report, we start working on this report. We also start working with the Sunset Review Committee, and our committee is made up of our board chair, Dr. Rajo, and our board vice chair, Holly Kaiser. Once we've completed the report, we're going to probably have discussions, not only with the committee, with the entire board, because the board will have to approve that. The finalized document will be submitted to the committees, and that happens around the end of the year, around December 1, I believe. And then around the winter of this coming year, they will schedule sunset review hearings, and those hearings happen in the spring. So if you want to see what a sunset review report looks like, or what our last report looks like, we have our most recent report on our website. I would encourage every board member, if you haven't already, I know I've shared it with many of you that are new to the board. If you haven't already, take a look at this report. I've been through a couple of these. I know Sharice has been through at least one that I'm aware of. So we've been through this process before. We kind of know what to expect. And I wanted to open it up for any questions that might come up, or any questions you might have at this time.
This is the moderator. Vice Chair Kaiser has her hand raised.
Sure.
Hi, I probably have a zillion questions, but the first one for me is, can you describe what the hearing is like in spring? What does that mean, going to Sacramento and meeting in a meeting with everybody, or can you let me know what that's like?
Thank you. Yes. So there are issues that are raised at every sunset review, issues that we may raise, issues that stakeholders might raise, or issues that are raised by the committee. And we are asked to answer questions, address these concerns. We address the issues from the past sunsets or sunset report, and we'll address the current issues. Typically, we're given a limited amount of time to make our presentation. They usually want us to be brief. We discuss, or are prepared to discuss, any of the concerns that come up, and the committee itself will ask us questions. Normally, these are done in person at the state capitol, and it's going to be the committee. It's going to be the board chair. It's going to be the board vice chair, or whoever the board designates, and I will be there, and we'll answer questions directly from the committee. And these usually go in order. There are several boards that are scheduled on any particular day at these hearings. So sometimes, depending on what comes up, you can be there at the end of the hearings or at the beginning of the hearings.
So one follow-up. Oh, sorry, one follow-up. So does that mean you actually know in advance what the major concerns are they're going to ask about?
Yes, they will tell us, they will ask us questions on the issues that they have. So we'll typically have a good idea of what the questions are going to be, but they can ask us any question that might come up, or any question that they have.
This is Sharice, and yeah, I was just going to say, normally they're going to give us a heads up. They're going to respond to our report and ask us to respond to their questions, and that'll all come up very close to when the hearing happens. And so we'll have kind of an idea of the things that they know of to talk about, but it is the purview of any legislator to ask any questions. So you can occasionally get a couple ringer questions that come out of nowhere. But that's DCA does a good job of working with boards to do kind of like maybe like a pop quiz, essentially. Like they kind of barrage you with questions. They do a test run just to get Paul and I kind of ready for whatever random things they might think could happen, so that we're all ready for anything that might come out.
That's actually a
those
really
questions.
good point. Yeah, we meet with all the other boards that are going up for sunset. We've already actually had meetings, and we kind of go in, as a team. DCA does a really good job of trying to prepare us to answer the questions so that we get all the information out there, that we're not unprepared going in. The other part of this is that our board staff will do outreach to these members of the committee and see if we can address any concerns or questions that they have prior to the hearings.
And another example of that is when I was at my previous board, we scheduled meetings with every single one of the committee members to answer any questions about our upcoming sunset, any questions they might have about the board, and just kind of do a meet and greet with board members. Obviously, that was pre-COVID, so I don't know what that'll look like come this winter. So we'll kind of have to just gauge that as we go on what sort of staff only, maybe online, maybe phone calls, what we do as outreach. Dr. Raggio?
I'll just ask my question. I was involved in one sunset review many years ago, and I remember the theme that we were told at the time is that the whole idea of sunset is that there may be the option to get rid of our board, and our purview is to try to prove that we are relevant, that we serve a good purpose for consumer protection in the state. So talking about our enforcement cases and things like that, and the need for oversight for these three professions is vital to consumer protection, and that was the theme that we went in with in answering legislative questions and things like that. I just wanted to know if that's how you still think about it.
Well, I think that's the ultimate question that they're asking. You'll see that at the end of the questions that the committee asks. So I actually, yes, I think it's important. We're going to answer questions that range from anything from licensing timeframes to enforcement cases. So yes, we want to make sure that they understand that there is a need to regulate these professions and that we exist to provide that consumer protection. Were you going to add something, Sharice?
Yeah, I was just going to say that might have been a theme definitely during some prior administrations that like to blow up boxes and consolidate things. But that they do always want to make sure the regulation of the profession by a board is still justified. So that is always the underlying theme. But I think a lot more nowadays is are we doing the best job we can? Are we being the most effective we can in protecting consumers? And also regulating the profession. So kind of hitting more on those broader goals. But that is always the underlying thing, is that if you are not doing well and you are not being effective, you can always get sunset sooner or be turned into a bureau or less. So that is always kind of the stick part of this process.
Yes, we do. And that's the nice thing about working with DCA and getting this information from, because at different times there have been different issues that have come up. I remember 10 years ago where enforcement was a big issue, and how the boards handled enforcement, and a lot of the focus was on that. And different issues come up for different reasons, so we will have a pretty good idea of what those issues are today that we need to focus on and make sure that we're covering in the information we provide.
Okay, thank you. Is there any other board discussion?
Sorry, one other question. This is Holly. How early do you find out the date in spring when the hearing would be held?
Oh,
That has changed
yeah.
in the last couple of years. It used to be that they were done right around the beginning of March. I mean, you could count on it. But I think with so many things that have happened and all the changes that are going on, I've seen sunset reviews happening much later in the year. So I imagine we'll probably know something, Sharice, by the end of the year.
I would hope, but I actually won't count on it. I know when COVID hit, it really threw the legislature, which is a very much in-person institution, into quite a bit of array, and like even getting our questions for sunset have been delayed significantly. You used to get them much earlier, and now we're just having to start working on previous year's questions because we still don't have questions officially. And then scheduling the committee hearings, they had to have fewer people, do more hearings. COVID kind of threw everything for a loop. So I know it got a little more spread out. It was a little later. Um, Committee staff have turned over. They used to have a lot of seasoned veterans for a long time, and so things were very set in stone and done a certain way, and that kind of changes sometimes. So hopefully we'll know by the end of the year, but I would go ahead and say you might actually be hearing about it in January, February.
Mm-hmm.
Okay, is there any further board discussion or questions?
Let me,
Seeing
can I go ahead and just give like a logistical update on all of this? Is of course that, when we come to your next board meeting in October, we'll be bringing you a draft report, Sunset Review report, where we have answered the questions to the best of our and the Sunset Review Committee's knowledge, and with all the information that we have. And that board members, it'll be a big, thick little booklet again, but we want to review it. If you have any questions, come ready to ask them, so that we can make our report the most complete and thorough look at our board and our licensing population. And then if changes are needed, if they're identified at the October meeting that we need to change something or ask for more information or run some more data or whatever, that we have the option of the November 5th meeting to bring a finalized additional changes made report to you guys for final approval.
That's an important point. We may need to call at least an extra meeting. I've been in sunset processes where we've had to call 2 and 3 extra meetings. They're usually meetings that are just focused on the report, and they can be relatively short just to get approval for revisions or changes to the report. But thank you for that, Sharice.
You're welcome.
Okay, any further comments, questions from the board? Seeing none, I'd like to ask for public comment on this issue.
This is the moderator. We've opened the Q&A panel. If you'd like to make a comment on this item, please click on the Q&A icon on your screen, type comment into the text field, and submit that to all panelists. And not seeing any requests at this time, would you like me to close the panel?
Yes, thank you.
It is closed.
Thank you. So I'd like to move on to agenda item 11, which is a DCA update. And I believe we have Brianna Miller joining us today to give us an update on board and bureau relations.
Good morning. Can you hear me okay?
Yes. Hi,
Oh,
Brianna.
wonderful. Hello. Thank you. Well, then I'll get started. Good morning, President Raggio and board members. I'm Brianna Miller with Board and Bureau Relations at the Department of Consumer Affairs. Thank you for allowing me the opportunity to provide you with a department update this morning. One of our top priorities in Board and Bureau Relations is appointments, and I would like to start with a brief overview. Currently, the board has 3 governor-appointed vacancies, a public, and I apologize if I mispronounce this, but otolaryngologist, audiologist, and hearing aid dispenser positions. DCA and all the appointing authorities share the goal of a fully seated, diverse, and effective board. Filling current and upcoming vacancies is a priority. If any members know any great candidates, or if any members of the public are interested in serving, please find the link titled Board Member Board Member Resources on DCA's homepage to apply for an appointment. Moving on to COVID-19 safety measures. On July 26th, the governor announced enhanced safety measures for employees in healthcare settings. To combat the spread of COVID-19 and protect vulnerable communities, California is implementing a standard to require state workers and workers in healthcare settings to either show full proof of full vaccination or be tested at least once a week. Workers who do not show proof of vaccination will be subject to regular COVID-19 testing and will be required to wear appropriate PPE. Questions from licensees about the healthcare worker requirements can be directed to the California Department of Public Health. Requirements for state workers are already being implemented, and DCA appreciates the assistance of staff. We will be in touch with any additional information we receive on this effort. And we know things are moving quickly, and there's a lot of information, both official and unofficial. Statewide guidance for the use of face coverings from the California Department of Public Health remains in place unless a local health jurisdiction issues a stricter public health ordinance tailored for the situation in their communities. And I believe there are several counties, including Los Angeles and Sacramento counties, that have issued health orders requiring face masks to be worn by both vaccinated and unvaccinated individuals while indoors. I encourage all members of the public to visit DCA's COVID-19 webpage for updates and resources on the state's reopening plan, public health guidance, vaccinator resources, vaccine distribution, and more. Remote meetings continue. So DCA is receiving many questions about when and how boards will meet again in person and whether they can also continue to meet remotely. The ability to meet remotely is tied to the governor's executive orders and the state of emergency. The executive order allowing remote meetings is set to expire on September 30th, after which time boards will be required to follow all aspects of the Open Meetings Act, including having publicly noticed and accessible locations, unless a change in law occurs. I think we all recognize the cost savings and increased public participation associated with remote meeting options. In the meantime, DCA will do all it can to assist boards and bureaus to transition safely to in-person meetings and keep you informed of any changes to meeting requirements. Board and bureaus are looking ahead to what changes can be made permanent for efficiency and employee well-being, such as telework and eliminating paper processes as well. And finally, I'd like to touch on required board member trainings and the learning management system. As a reminder, 2021 is a mandatory sexual harassment prevention year. This means all employees and board members are required to complete this training this year. Please also be advised that you can now access this training through the Learning Management System, or LMS, which is DCA's training portal. We have created profiles for each of you in the LMS and informed your executive officer and board staff of the steps you will need to take to log in and access the training. Board and Bureau Relations is also happy to assist you with any questions or concerns you may have about using LMS. And ultimately, the LMS will be the portal to house your training records and may also be used to sign up for other mandatory trainings. We're proud to announce that at this juncture, LMS now includes the ability to also register for the board member orientation training. So that has been now incorporated into the LMS. And as a reminder, newly appointed and reappointed board members are required to attend board member orientation training, or BMOT as we call it for short, within a year of appointment or reappointment, and the next training will be held via WebEx on October 13th. So as always, Board and Bureau Relations is here to help, and if there's anything we can do to assist your board, please reach out. And that concludes my presentation. I will hand it back to President Raggio. Thank you for your time.
Okay, thank you, Brianna. Did I understand you right? I just want to verify something you said, that the in-person meetings would resume after 9/13, 9/30, excuse me, September 30, or is that subject to change?
So as it stands, and I apologize if I just spoke over someone. I heard a voice in the background. But as it stands, the governor's order is set to be effective until that time. Of course, things are fluid right now, with the Delta variant. Things are subject to change. But so we're operating with how things stand, and knowing that things could change. And of course, if they do, we will be in communication with boards and bureaus as soon as we're aware of that.
In terms of the sexual harassment program that we have to do, usually we get an email from DCA itself and given a kind of a cutoff date when we need to complete that. Will they come from DCA again in that form, or will we get those from our own board staff?
I'm not aware of an email from DCA going out this year. I could definitely look into that to see if it has occurred or will occur, and I'm happy to work with your board, staff to help get you whatever information you need to help you complete the training.
Okay, great. Thank you.
Of course.
Are there any other board questions or discussion? Not seeing any. I'd like to ask for any public comment on Ms. Miller's report.
This is the moderator. We've opened the Q&A panel. If you'd like to make a comment on this item, please click on the Q&A icon on your screen, type comment into the text field, and submit that to all panelists. And not seeing any requests, would you like me to close the panel?
Yes, thank you.
It is closed.
Okay, thanks again. And thank you, Brianna, for your update. We really appreciate learning all of that information.
Thank you.
I'd like to move on to agenda item 12, update on speech and hearing related DCA waivers related to the COVID-19 state of emergency. And I believe that's under tab 12, and Sharice will lead this discussion.
Thank you, Dr. Raggio. Oh. Sorry, I spoke over somebody.
No, go ahead.
Okay. So the update for now is that all of our current waivers, the continuing education requirement waiver that allows a delay in the requirements, reactivation waiver, RPE and SLPA, SLPA, direct supervision requirements, and the hearing aid dispenser and RPE extension, license extensions. They are all currently in effect, and we continue to work with the Department of Consumer Affairs and the Director's Office to continue to get waivers extended as long as they are needed. There was a discussion of winding down the waivers. However, I have not heard any updates on that. So currently, I would assume we will continue to work with them while there is still a need. So we will continue to advocate for these to be approved and continued in their current status. And then, of course, as soon as we hear any word that they may decide to stop issuing waivers or start winding down those waivers, we'll hope to give appropriate notice on our website and via our listservs. And of course, if you go to our website on our top page, if you're not getting emails from us either about licensee information or laws and regs changes, please go ahead and click on the icon at the top that says update your email information with the board, so that way we can have the most up-to-date email lists and get everyone the information on the waivers and any other COVID-related updates at that time. Does the board have any questions?
Okay, seeing no further discussion or questions from the board, I'd like to ask for any public comment on the waivers.
This is the moderator. We've again opened the Q&A panel. If you'd like to make a comment on this item, please click on the Q&A icon on your screen, Type comment into the text field and submit that to all panelists. And seeing no requests at this time, would you like me to close the panel?
Yes, thank you.
It is closed.
Thank you. And I'd like to thank the Charisse and the rest of the board staff who worked on these waivers. I know the professional communities are very grateful for the work the board has done to try to access and make these put these waivers into place during this really difficult time. So I do want to thank you for that.
President Raggio, this is the moderator. I do see that we have a member in our attendee list with her hand raised.
Thank you.
If I could, I would like to check, make sure potentially she could not find the Q&A.
Okay.
Okay, so Michelle, I've sent you a request to unmute your microphone. Michelle, I see that you're unmuted. I cannot hear you at this time.
Okay, can you hear me?
I can. Did you have a public comment on that last item?
I did. Technical
Okay,
issues
please
with
go ahead.
our screen.
No problem.
This is Michelle Linares. I'm the chair for the California Speech and Hearing Association, and we did want to say thank you very much for helping us with all of that during COVID. We can't tell you what a lifesaver it was for us, for all of our shareholders. There was some discussion at one of our board meetings that there are regulations that really stop us. So it was executive order from the governor's office, if we understood correctly, that was allowing these changes to be made temporarily. So moving forward, is there a plan to update regulations to get any of these things that have helped us to become more permanent? Is there anything that we need to be looking at or working on with you to get you metrics, or is there anything you can share about life after executive orders and COVID? Thank you.
Dr. Raggio, would you like me to speak to that?
I was going to say, I'm going to throw that to Charisse or Paul.
No problem. So, life after waivers is actually an interesting and tricky question. So, the waivers, the board can't waive its own regulations. We just don't have that authority, which is why we needed the executive orders in order to do that during the COVID-19 pandemic. So, as soon as the waivers expire, everything goes back to the current state of the current regs that are adopted and promulgated. So, I want to put that in reference. So when we talk about updating the CECPD requirements yesterday, when we talk later on today about updating SLIPA changes, and when we talk about RPE direct supervision, all of those changes, while we're talking about them at the board, have not been promulgated. They have not gone through the formal rulemaking process to its completion and inserted into the regulations. So right now, as soon as waivers expire, we go back to no telesupervision and we go back to all CECPD requirements that are currently in law go back into effect. So we definitely have we have our new staff member to complement so that we have a full-time and a part-time legislative and regulatory analyst to help us get through our backlog of regulations, but they do all still have to go through the process. So
Can I
current
add something to that, too,
requirements.
Charisse?
Yeah, go ahead.
Just as far as regulations go, to Michelle or to anyone else that is interested in change, those changes should be brought to the board for discussion. And it starts with a discussion, but just to be clear, there's no plans on just removing all the regulations that we had to waive due to COVID-19. We do want to address needs as they come up, and we are definitely looking at living in this new post-pandemic world. But I think we have to handle those issues, one at a time as they come to our attention.
And with consumer protection as our utmost concern.
Right.
So yes, again, once the waivers are gone, we have to go back to the current law, which is the statute and the regulations we have in effect. And of course, our revisions to those regulations that are in the process right now will need to continue. And so hopefully we will be ramping up on those changes. But again, it's very important to be a part of the board meeting discussions on regulatory changes, and the suggested language in those regulations is what the board is trying to achieve and trying to change. And of course, none of those go into effect until it's been through the full rulemaking process and approved by the Office of Administrative Law, just so it's very clear to everyone.
I hope that answered Michelle's questions. Is there any further discussion on this topic? Seeing none, we had a time certain of 11 a.m. for item number 13 on our agenda, discussion of cognitive screenings. So obviously we're pretty early for that. So we're going to jump around a little bit on the agenda and move to item number 14A, which is the regulatory report, update, review, and possible action on board regulation packages. I believe that our legislative analyst, Heather Olivares, is going to take this topic on. I would like to say before we start, though, that the format of this description is really well done. And it's so easy to follow exactly where every package is, regulatory package is, by the way you've displayed it here. So my compliments on that. Heather, can I give this to you?
Yes, good morning, everyone. Heather Olivares, Legislation and Regulation Analyst. Thank you to Board Chair Raggio for the introduction of this report. This is a new report that we put together for you for this meeting. And as Dr. Raggio mentioned, it includes a timeline for visual of the regulatory process and the number of steps that are still needed to give you a guideline of where we are in the process and where we have to go. And so we do welcome any feedback from board members and the public if this new report format is working for you, or if there's additional information you would like to see moving forward. So with that, I've prepared a list of the board's regulatory packages and their status in the rulemaking process. The first one is the implementation of speech language pathology and audiology fees. We are happy to report that this regulatory package was approved by the Office of Administrative Law on June 29th. Board staff is currently working with DCA to implement the fee increase. So they're not actually, licensees are not paying the higher fees yet at this time because we need to make changes to the IT system, update all of the forms, and revise the renewal notices. And that process is all ongoing at this time. The next regulation on your report is the professional experience, direct supervision requirements, and remote or telesupervision regulations. This regulatory package is in the DCA regulations pre-review stage. Board staff have received feedback from our legal counsel, and we incorporated the recommended changes prior to submitting the package back to legal on July 16th, 2021. This is a back and forth process between board staff and legal as they raise concerns. We address those concerns or provide additional information as needed in order to move the package forward. Once it is approved by our board legal counsel, it will be submitted for the initial department review, which involves reviews by DCA, both the legal and the upper management in legal and budgets, the executive office, and the Business Consumer Services and Housing Agency. On the back page of your report is an update on the speech language pathology assistance requirements. This regulatory proposal is still in the regulation development stage. We have been working with our legal counsel on the proposed regulatory language, which requires review and approval by the board. So we will be discussing this regulatory package later in this meeting to review the changes and discuss any additional changes the board may wish to make. The next item is the uniform standards related to substance abusing licensees. This regulatory proposal is also in the regulation development stage. DCA recently updated the uniform standards, which requires review and approval by the board, and we will be discussing this proposal later in this meeting. And then finally, the last regulatory proposal is the audiology licensing requirements. This proposal is also in the regulation development stage and will be discussed later in this meeting. That concludes my report, and I'm happy to answer any questions from board members and the public.
I just have one quick question about the fee schedule or the increase in fees. Do you anticipate when those will be implemented?
This is Charisse. I'll go ahead and jump in here for Heather. So currently, the licensing staff and myself are working with the information technology branches and cashiering in order to implement this. As most licensees are probably aware, you get renewal notices ahead of time. So part of this is planning out an implementation date so that it can go into effect as a date certain, and that your renewal notices hopefully will reflect the updated fee. And part of that, of course, is jumping in line with a lot of other people getting changes within our databases and systems. So what we are hoping for is later on this fall/early winter, maybe in November or December. But as soon as we have a date certain, we will absolutely be putting that out via email blast on our website and every place that we possibly can to give as much advance notice as possible. So currently, we are in that process. It takes a little bit of changes in the system. And of course, we have some older systems, so not everything is fast and easy. But we will get those up and into place. And then as soon as we know of a date, and it'll probably be a couple months out, that way we can let everybody know.
Okay, thank you.
You're welcome.
Are there any other questions from the board or discussion?
At this point, why don't I go over 14E, if that's okay?
Well, I was just going to ask you and Paul, since we do have an hour and 15 minutes before the next agenda item will come to be, would it be prudent to just simply go through these C and D as before you get to E, or would you like to just go to E?
Since I think C and D are going to be pretty big discussions, I think it might be easier to go to E and 15 maybe, and then if we still have time, begin the other discussion.
Okay, would we like to go to public comment on A before we go to E?
Sounds good to me.
Okay.
My apologies. WebEx was giving me a little bit of trouble. I have opened the Q&A panel. If you'd like to make a comment on regulatory item A, please click on the Q&A icon on your screen, type comment into the text field, and submit that to all panelists. And seeing no requests, would you like me to close the panel?
Yes, thank you.
It is closed.
All right, so let's move to agenda item 14E, discussion and possible action regarding audiology licensing requirements related to supervised clinical professional experience. We did talk about this somewhat yesterday, and I believe Sharice is going to lead our discussion today about this.
And so I'm going to go ahead and just provide the update that the Audiology Practice Committee is still considering options about what kind of clinical rotations and experiences can count towards the 12 months of satisfactory completed supervised professional full-time experience, and that we will continue to work on that. We're going to be sending out a survey to solicit input from audiology programs so that it can best inform our choices and decisions at the next Audiology Practice Committee, at which point we'll hope to look at some language changes and updates. And after that, we would hopefully bring it to the full board for consideration. And that way we would be working towards a coinciding package where the legislative changes that are needed would go into effect in January 1 of 2023, and that our regulatory package would be ready to go as soon as that legislation was approved. And that hopefully that would speed along our package.
Okay, is there any, are there any board questions or discussion about this topic? Well, I, for one, am glad that we are making progress with this very important element of audiology education. So I'm pleased to see the progress we've made so far. At this point, I don't see any board questions or discussion. So I'd like to, because this is an important topic, I would like to open it up to any public comment.
This is the moderator. We've again opened the Q&A panel. If you'd like to make a comment on this regulatory item, please click on the Q&A icon on your screen, type comment into the text field, and submit that to our panelists. And I see a request from Michelle. Michelle, I've sent you a request to unmute your microphone. And just as a reminder, our public comments today will be limited to 3 minutes.
Thank you very much. I just wanted to ask if we can ensure that we have training sites that are, businesses that are also at the table for those discussions, because I think that what happens in academia and the requirements that we need and how that's actually implemented in certain businesses or different structures, it matters. It really matters because it starts to lessen the amount of training sites available or the want for people to participate in that way. And so if there's any way that we can kind of balance out that conversation with that aspect, because in implementation, I think it is where things start to fall apart sometimes, or where people say this is impossible, we're not going to take a student, and those kind of I guess that's it. That's all I want to say. I just think that's something that would be really important just to balance out the conversation. Thank you.
Michelle, would you mind defining what you mean by businesses?
I think she has to be unmuted.
Yep.
Yeah, Michelle, I sent you another request. There you go.
Thank you. I wanted to just mention like audiology practices or hearing aid dispensers, or even speech clinics. When we do accept students or people doing their externships, it takes a lot of resources from our business, and we do it with a lot of love because that's how we give back, and we have contracts with many universities as a field training site. But when we are dealing with our patients, our consumers, it takes a lot of hoops to jump through just to even let them know that, we are a training site. Would it be okay for someone to be present? Can they get those hours for that? How are they watching? What are they doing? So I guess that's what I mean, that implementation of these regs, we always try to follow everything to the, to the letter of the law. And, there are times when we just have to tell some students, I'm sorry, this isn't going to work out, or this is difficult, or, this is come to us when you're fully licensed. I think that those are some of those limitations that, when we look at it, it gets difficult to implement because it takes a lot of resources. And so I would like to hear how practices implement these any regulatory changes or how they interpret them, is it a burden on the business? Just because we need more training sites, we need more people to take our students. And I think that that's where the translation of things sometimes gets all muddled up, right? And so that's what I mean by businesses.
Okay, I'd like to respond to what she's saying, and I certainly appreciate the notion that it's hard to find sites to place students. That's definitely the case. But let me tell you how the board looks at this process. We have been working with the AUD programs throughout the state of California for probably the last couple of years, developing notions of what their needs are, what student needs are, program needs, as well as consumer needs to address these issues. So generally, we don't go out and seek input from audiology practices who might take a student per se. Rather, we leave that to the program itself. They have their MOUs designed and developed with various local agencies who will take the students from their particular programs. Sometimes it's a statewide endeavor. And we're always here happy to answer questions on behalf of any entity who's working to provide this training. But really, we don't solicit their opinions and so on, although we're happy to entertain them. We send out our notices of our public meetings, and hopefully anybody who has an interest would attend, be it a site that would take a student or somebody who's placing a student. But generally, we work through the programs and try to assist them, and they do the negotiations with those outside agencies. But we're well aware of the problems and would be as helpful as we can be. So I hope that answers your question about how these regulations will be implemented. It's really us through the programs and to the sites.
And I would add,
yeah.
I would just go ahead and add that I hope that training program directors are reaching out to their field and training partners when they're providing input. So hopefully we get everyone's input when we're asking.
Yeah, in fact, that's inherently what happens, is because they do have to seek these sites for their students to get their rotational trainings. They have to develop an MOU. They have to know what the rules and regulations are, so to speak. And we have been working with these program coordinators who bring back any concerns that they have from these agencies. And unfortunately, in this particular meeting, there aren't very many people from those programs here, but generally there are. And we've had special meetings just with them to try to understand their concerns. Any other comments from the public or concerns? Questions? Okay, Paul?
Yes, I just wanted to ask if we're done with this issue, now that we're in the world of regulations and we have our regulations council, if we could cover 14D regarding uniform standards next.
Sounds like a good plan. So we've closed the public comments. So let's move to 14D. This is the discussion and possible action to adopt uniform standards related to substance abusing licensees in Title 16. I believe Heather is going to lead this discussion, but I would like to say that I understand that this, the need to get to adopt uniform standards is long-standing. We've had it for a long time and would like to move this one forward. So Heather, can I turn this over to you?
Yes, of course. So the uniform standards came about through legislation. In 2008, SB 1441 created the Substance Abuse Coordination Committee under the Department of Consumer Affairs. The committee was required to create a set of uniform standards to be used by healing arts boards to deal with substance abusing licensees in the healthcare professions. This committee developed the initial uniform standards in April 2011, which covered a wide range of issues related to substance abuse rehabilitation, including clinical diagnostic evaluation, testing frequency, standard of treatment, consequences for violations, and more. However, based on changes in developments in testing and research and technology for drug testing, there was additional legislation, SB 796 in 27, that required DCA to reconvene this committee and update the uniform standards. So that work has been done, and DCA recently released new uniform standards regarding substance abusing healing arts licensees. The board has discussed this issue a number of times and was initially going to do separate uniform standards and then combine it with the disciplinary guidelines. And so now we're at a point where we do need to be working on this through the formal regulatory process. However, the board does have discretion to adopt uniform standards as a separate document or to combine them with disciplinary guidelines. I have compiled a number of examples from other boards that are included in your materials, and I've also included draft regulatory text as a starting point that we can use to decide how we're going to be moving forward to adopt and address this issue of uniform standards. So I'll just point out and give a brief overview of the materials in your packet. The first example you have, well, if you turn to the blue tab or the blue paper and go past that, you'll see the draft regulatory language. That is our starting point that we can use if we are moving forward in formally adopting something today. But then if you go in the next blue tab after that, you will see the uniform standards that were put out by DCA. And then in the blue, after the blue paper after that, you'll see the optometry board regulations. And these are very similar to the other regulations on the next tab, that is the occupational therapy regulations. Both of those have incorporated the uniform standards by reference into their regulations. So what that means is they took DCA's document and just incorporated that entire document into their regulations. They didn't further expand on it or further explain it. They just took the entire document and that becomes part of their regulations. Another board that you have their example following that is the physical therapy board, and they are currently going through the formal regulatory process. And what they are doing is they are adopting disciplinary guidelines at the same time as incorporating the uniform standards by reference. So you'll see that's quite a lengthy document that they are doing. They are trying to do both their disciplinary guidelines and uniform standards at the same time. And then following that information, you'll see what Board of Psychology is doing, and they adopted a uniform disciplinary guidelines and uniform standards document that is incorporated by reference into their regulations. And then the final example we have for you is the dental board, and they included probationary terms and conditions to be used in every case where it has been determined that the individual is a substance abusing licensee. So board staff, our recommendation is the board reviews these documents and discusses the provided materials. And if the board has a preference for how they would like to move forward, if they would like to adopt uniform standards as a separate document or do work to do disciplinary guidelines and uniform standards at the same time. This item can either be adopting something today at this meeting or possibly having the board's enforcement committee work on this topic. So with that, I'm happy to answer any questions or provide any more details as needed.
So you're not recommending that we put the disciplinary guidelines in with this standard as other boards have done necessarily? Is that right? Am I even asking that right?
Yeah, we're not yeah, I understand your question. If so, the board has discretion. The challenge, if we are also going to implement changes to disciplinary guidelines, is our disciplinary guidelines right now are two separate documents, one that applies to speech language pathology and audiology, and another disciplinary guidelines that apply to hearing aid dispensers. So for our board, since we have all of the different professions, it would be a large undertaking to do all that work to update the disciplinary guidelines. But at the same time, it makes sense that since both uniform standards and disciplinary guidelines are so interconnected, that it does make sense to do them together. It's just a large workload. So it's really up to the board if they want to just get uniform standards done and move forward with something more simply, or if they want to go through the process of the enforcement committee combing through everything and doing everything as one big project. The discretion is really up to the board and board staff. We don't have a recommendation on which way is better because there's pros and cons to both ways.
My instincts are to stick with uniform standards regulation on its own and worry about disciplinary guidelines later, because it's been years trying to get this adopted. That's just my instinct, is to look at it that way. Karen Halbo, do you have a comment you'd like to make?
Yes, thank you, Madam Chair. As the Reg Council, the recommendation that I would make is, if you'll notice, the dental board's approach is to do an adoption of the uniform standards separately, but to do it as model orders. And that to do that, I'd recommend having the enforcement committee look at just doing an adoption of uniform standards as model orders. What they are is then you have like drag and drop language that the district attorney generals and the ALJ, the administrative law judges, can use and will use in disciplinary orders. And so it's a way of ensuring that things move more smoothly through the process when you get a substance abusing licensee, and that it follows these suggested uniform standards. The issue with adopting just the uniform standards as the language was adopted by the legislature is it is not clear to the people to whom it will apply. Those things are saying, those standards say things like, the board will hire someone to do this sort of review, and there'll be this sort of supervision and this and that. And a person who's got the drug and alcohol problem trying to figure out, well, what does it mean for me? It's very complicated. And we have clear permission. It's in the public domain to rip off and copy and use as, make it appropriate for speech language, but not that their model orders are mostly drafted. So I don't think it's so much work to do adoption of the uniform standards as model orders so that it's understandable to the regulated people and useful in the discipline process, versus just, we're going to adopt, here's this statute, this group of uniform standards the legislature adopted, which is kind of hard to follow. Your disciplinary guidelines will take a lot of blending together of the two, and it can and it will get done. But I would suggest to move forward on the uniform standards, because it's useful for licensees to know that they do apply to your licensees. But to do it as model orders so that it's clear what it means to the people who will be subject to those provisions. And I think that if you referred it to the enforcement committee, it would not be hard for staff to provide them with mostly drafted material, because we would work from what the dental board already got through the Office of Administrative Law as translating the uniform standards into orders.
Can I just clarify that our model orders some sort of standard guidelines, so that if this violation, that's the consequence? Is it like that?
Yeah, if a person is found this, the administrative law judge will order that the respondent must be in this program, must follow these guidelines. It just, the language as it's written is sort of aimed at the programs. It's aimed at boards and bureaus to handle substance abusing licensees in the same way. And it's hard for the licensees to follow how that works. So it would make sure to incorporate everything in the uniform standards, but provide this drag and drop language that the district attorney generals will put into the prosecution, and the administrative law judge will put in the order when they do order a licensee to get into the program and hopefully become reformed.
Okay, so you're recommending that we not adopt simply the proposed uniform standards regulatory language today, but rather refer this project, if that's the right term, to the enforcement committee to see the easiest way to merge disciplinary guidelines into this uniform standard, so it makes it cleaner in the long run?
Well, not to merge the two. You can have a regulations package and adopt regulations that incorporate by reference model orders for the uniform standards. So instead of combining your disciplinary guidelines and the uniform standards, you'd get the uniform standards within your regulations by incorporating a document that sets out the uniform standards and provides model orders for use in the discipline system. So that it would be, so it's a separate document, and the work on combining your disciplinary guidelines, that's a separate reg package that will continue. And if at any point they want to put in the uniform orders to that can be done, but a uniform orders package could be pulled together, dealt with by the enforcement committee, looked over, and started into the regulatory process probably before the kind of writing and combining that has to be done for your disciplinary guidelines would be completed.
This is all a little Greek to me, so I'm following and then not following. So I was wondering if Heather would, well, I see we have a couple board members with questions, so let's have their input. Todd Borges?
So if I understand this correctly, then we're basically saying, okay, whatever the disciplinary standards are, we're going to agree that that's what the discipline's going to be for whatever the situation might come about, because there's a model already in place.
Well, what you have when you adopt uniform standards, because these are required by law, you're supposed to work with substance abuse and licensees following this model. So the existing disciplinary guidelines stay in place, but what the language of, I believe, the motion that is among the packet says that if it's determined to be a substance abusing respondent, then you're going to use the model orders and uniform standards. It's basically putting in regulation. Yes, everything goes by the disciplinary guidelines. However, there's a little off ramp if it's determined to be substance abusing, but that's what the legal requirement is. So you want to have the regulations match that.
But the model that we're going by, we basically then have to understand, okay, what exactly are the different disciplinary guidelines that we're agreeing to?
Well, you're not changing. What are you mean? What are the treatments? How you handle someone who's a substance abusing licensee?
Right, because it just sounds like we're not necessarily coming up with our own standards as to what we think the treatments and things should be. We're just adopting whatever the model is that's currently in place.
Yes, you'd be following the model that was created in SB 1441 that was passed so that health professions handle substance abusing licensees in a certain way.
So is this in essence giving us a shortcut?
Yeah, this was worked out through the medical board, physician assistant. A lot of different boards had input. DCA worked on this for quite a while, and then this was passed as this is how you want to deal with because the potential harm if they don't reform. So how often do they have to have checks, chemical checks? You know how they're managed. There's a whole structured system already developed. And that's generally the supervision of and testing is handled through a company that the department contracts with on behalf of all. The supervising company that handles these matters and deals with the rehabilitation, supervision, and testing of substance abusing licensees.
Thank you.
Let's see, Holly.
Yes, thank you. So I'm going to just check my understanding of this, and then anyway, so it sounds to me that I think it was the optometry board, they adopted, they just said, we're going to refer to the uniform standards, and they didn't integrate them or incorporate them into their discipline guidelines. The physical therapy board, they did the opposite. They really went through incorporating them in detail, and then the kind of mid-range, I guess, is what the dental board did, where as you said, you're pasting it into the right place. So if that's correct, I would like just maybe you go through an example, just like one example, explaining with us looking at the dental example and how that's referring to the uniform standards. Because I think I get it, but it might be helpful if you walked us through that a little bit, how that looks.
Okay, I got to dig for a minute. This was a lot of materials put in, and I did not prepare it. Let me do that, and I'll get back to you after Paul and Charisse have had their chance to talk too. I'm digging as we speak.
Oh, thank you. I hope that makes sense. It was just like in the last section of our binder in this section that has the dental, and it looked like it was the simplest.
The last one,
yeah.
Dr. Raggio, can I just address a couple of things?
Oh, absolutely.
Well, one is the uniform standards is something that we've had several roadblocks over the past several years. This is something that we've been asked to implement, and I think that coming upon sunset, we know that this is something that we're going to have to address. So we should be prepared for that. If we were to adopt the language that was provided as is today, I know that we could move forward with this. The cons are that there could be roadblocks in trying to get the rulemaking file promulgated through OAL. I don't know what that would be, but that's kind of what I'm hearing. On the other hand, I wanted to also make the board aware that we have worked on disciplinary guidelines. This is just for your information. And we have language that the board looked at. I think we're going to be looking at that again. That is a long process. I've never been part of a disciplinary guidelines discussion that didn't take a lot of time, thought, and effort. As far as what what we're discussing with the dental board and the model orders kind of format. Just to put it simply, they're written in the same format that disciplinary guideline terms and conditions are written. So it's a little more specific, and it would answer questions that someone might read when they're looking at the uniform standards document, the original document. That doesn't mean that one or the other cannot be done the way they're written. It's just a different way of approaching it. So I just wanted to help understand what the dental board has provided is written in a disciplinary guidelines type format. That's all I had.
That's helpful, Paul. Thank you.
Heather?
Yes, I can just circle back and answer Holly's question and kind of try to help digest this information. So I'll just start, we'll kind of go through, I'll start which is the easiest way to address this issue, and then work up to what is, for lack of a better word, which is the hardest way to address this issue. So if you want to turn to the Board of Occupational Therapy example, their regulations, what they did is they had existing disciplinary guidelines that they did back in 2013. And they said in their regulation, the disciplinary guidelines shall apply to all disciplinary matters. Then if you look below that in the section that's 4147.5, they adopted the DCA uniform standards, and they put in there the uniform standards describe the mandatory conditions that apply to a substance abusing licensee. And then down in section B, it says, if the conduct found to be grounds for discipline involves drugs and or alcohol, the licensee shall be presumed to be a substance abusing licensee. So basically what they did is they took the uniform standards that DCA put together, they incorporated them by reference into their regulations and said, if the issue is a drug and alcohol, that licensee is automatically assumed to be a substance abusing licensee, and then the uniform standards apply. So that's kind of, so to speak, the easiest way to address this issue. We're not interpreting anything. We're just basically taking what DCA already did and said, we're going to use this document if anyone is substance abusing. The next kind of, let's just say, middle ground way to address this is what the Physical Therapy Board did. And what they did is they've been updating their guidelines, and in the same regulatory package, they are incorporating by reference their new guidelines. And then they give, this is in section 1399.15A, they say they can deviate from these guidelines if there is the presence of mitigating or aggregating factors, such as the age of the case or evidentiary problems. Then in section B, they go on to describe if there's an issue of sexual offense, then a different standard applies. And then in section C, they say if the conduct found to be a violation involves drugs, alcohol, or both, and the individual is permitted to practice under conditions of probation, a clinical diagnostic evaluation shall be ordered as a condition of probation in every case without deviation. And then in these situations, that's when their uniform standards apply. And the uniform standards they're using is the DCA standards that they're just incorporating by reference. They're not further fleshing anything out. Then the next way to do it is what the dental board did. And as Karen was mentioning, they took DCA's document, but further fleshed them out to be model orders that can be used in disciplinary cases. And then they took that document and incorporated by reference into their regulations. They did not do anything with disciplinary guidelines in their package. They have a standalone model orders for uniform standards. Then going back to the most complex way to do it is what Board of Psychology did. And they incorporated uniform standards into their disciplinary guidelines and adopted that as a combined document that addresses disciplinary guidelines and for their substance abusing licensees and incorporates the uniform standards. So that's kind of the progression of the different options the board has, ranging from something super easy to do that we could adopt today and move forward on versus something that may take years to flush out if we go the route of incorporating updated disciplinary guidelines and uniform standards. Hopefully that makes more sense, and I'm happy to answer any other questions.
Yeah, thank you so much.
It feels to me like because these regulations have been around for so long and we do want to move this forward, that it might be best to accept the proposed uniform standard language that is in this current regulation or proposed. Otherwise, I think we have to delegate this to the enforcement committee to really look at all these different examples and determine whether we want to incorporate some of these methodologies that the other boards have used or not, or which one, if we want to do that. So let's continue the discussion with Gilda.
Yes, thank you. I had a question regarding the proposed text. When there is that section that's highlighted that says, quote, standalone documents, would that be something that is, that document, is that something similar to what OT did, or what is that referring to?
Sure. So that is referring to if we want to go a super easy route and just incorporate by reference what DCA already did, or if you're comfortable with exactly what dental board did and don't want to flesh that out, we could also go that route as well. So basically it's just a placeholder in case the board is moving forward with formally adopting something today. We would just change where it says standalone document, and whatever that document is titled, we could just say we're adopting this regulations, making the change that where it says standalone document is the name of the document that's incorporated by reference. It just gives us something, because in order to formally adopt something, you have to actually have the language. So it's just the placeholder for today.
So that paragraph that OT used, 4147.5, would that be appropriate to insert in there?
Well, these regulations are laid out to apply to our actual code sections where we would want this to go in our current regulations. And so we're taking what's already current regulatory language and making the appropriate changes based on what's relevant to our board.
Okay, yes. So I was, referring something similar to what they did, where they just inserted that paragraph and it is referenced.
Correct.
If we adopted the uniform standards as written today for our board, would we be able to come back later and look at the disciplinary guideline aspect, would that be even recommended?
We actually plan on bringing disciplinary guidelines back to the board at a future meeting. We have done a lot of work with the disciplinary guidelines, but we certainly need this board to look at them and possibly make some updates.
Gil, did you have another question, or you just didn't take your hand down?
I didn't, but I have a comment. I do appreciate the proposed text and support inserting a document that's, well, the title of the document that would be referenced, especially if we're going to be able to look at this later and go more into detail how we want to handle it. But since this has been in the works for a while and the work has been done regarding the proposed text, maybe we can just have the discussion on how we want to insert that standalone document title into this current document that's in here for our reference.
Heather, do you want to address that?
I think that the board definitely has discretion to do that, but as the challenge that our Regs Council brought up with that is that nothing is fleshed out. So, you know, nothing is interpreted with that method. So there's still, when you guys go into enforcement cases, the DCA document may not really help you in those cases because there's no model orders for the ALJ to use in how the case would be decided.
Can I just clarify that as well? This is Charisse. So the uniform standards aren't written as model orders, so it's not as simple as saying, here's exactly the term and its wording, and so on and so forth. The standard is there, what it will be required, but it's not as clear as a regulatory or the proposed decision language, which is it's not just testing at this interval, because the uniform standard lays out, you know, you're going to test at this interval for these times and blah, 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 blah. The order or proposed order language is just cut and paste into the orders. So there does end up being a little more work for the DAG and the enforcement team to make sure that the uniform standards that are adopted by reference, if we don't change anything, that they do get incorporated properly into proposed decisions and orders. But again, that's a translating one thing that's not in order language to the order. Did I explain that right, Paul?
Yes, that's correct. The different proposals don't really change a lot from that standpoint. For instance, an order may say that a probationer has to submit to testing, just to keep it really broad. It's then the staff who takes these standards and determines how much testing at different phases during the probation. They're standards. That's what they are.
Is that what happens now?
Okay.
Well, what happens now is a ALJ will look at our current disciplinary guidelines, and he will just say, for instance, that the probationer has to submit to biological fluid testing, and then we determine what the appropriate amount of testing is. That's how testing has been done and is still done. Uniform standards give us some guidelines on how often we should test.
So it isn't our discretion about that. It's in regulation. Or
Oh, no. It is our discretion. We use the guidelines as a guide to determine how often to test.
okay. Karen? How about,
Yes, thank you. The uniform standards being adopted simply as the uniform standard document, as they did for optometry and occupational therapy, gets at least clarity out that this board is following those standards. But I'm regulations counsel. You have board counsel. They work with the people when they're doing enforcement, and just adopting the standards without having model orders is less work for me and much more work for your staff and dealing with enforcement issues down the road. So the idea of doing it with model orders, given that there is some existing language that can be followed, it seemed to me you could do it pretty quickly. But that, I guess, would be going to the enforcement committee and then having it come to a vote on the specific language in the model orders at the next meeting. I don't know. I'm hearing people sort of saying, well, we need to get this done. But there is sort of your short-term pain, long-term pain calculation going on here, and it is less clear, both as something that someone who is a practitioner with a drug or alcohol problem trying to figure out, well, what does this mean and how does it happen? They can understand it better, and it can be simplified and streamlined with the model order approach, but it would take a little more time, not years. I mean, what I'm trying to say is at the next meeting, you should have that document ready to go and have it go through the enforcement committee and then come to the board as a whole. But the board is welcome to say, we just want to adopt uniform standards so that we have it done and it's in our regulations and we'll clean it up later. The lead attorney looked at me and said, OAL might say there's a clarity problem. Well, I would argue back. If other people were allowed to do this earlier and it wasn't a clarity problem then, you can't hold it against us now. So whatever package the board decides to go with, we're going to push through and get done. But that's what you're balancing is, are you putting a Band-Aid on something and not really getting the problem cleaned out? Or are you gonna say, let's get this a little more efficient now and then move forward so that the uniform standards are incorporated with orders? And either way, clearly boards have all handled this differently, and there are still other boards who haven't adopted them yet. So unfortunately, you're right in the middle of the pack. There's lots of options.
could I ask Paul or Heather to address exactly what Karen just said? Or her recommendation here?
I actually want to go ahead and chime in here as well.
Okay.
So let me give two things. Number one, I love Karen, and she's super helpful to work with. And but there is one thing to keep in mind, is that means if we're going to take something to enforcement committee's got to meet in between now and October. Right now, we're also going into sunset review, which means staff is going to be doing a heavy workload and a heavy lift to do the sunset review report and have that completed before your October meeting, along with all the other things that are high priorities that we want to continue to move and press forward with. Karen's big point, you have options here. We can put a Band-Aid on it for now and adopt the uniform standards as they sit, right? That puts a Band-Aid on it. It says, hey, we've adopted them. It gives us something legally to base all of our orders on. It says we're using the uniform standards. But it doesn't do the whole shebang, right? The whole shebang is a lot of work, but there's also a consideration here about what do you want the whole package to look like? Do you want something like where Dental Board has done a separate disciplinary guidelines and they have separate disciplinary orders for uniform standards in a separate document? Or in the long run, do you want one super incorporated big document? Again, there's those varying levels of difficulty, length of time to review and go through the enforcement committee, line by line, are we doing all the right things and updating and integrating both of the disciplinary guidelines? So there's options, and there's just, because we're not first out of the gate here, there are a lot of options, right? So you can just adopt them so that we have them. It's still more work on staff, but it's something that's there. And then in the meantime, decide what to do with the disciplinary guidelines and how far you want to incorporate the uniform standards. Some boards have just slapped them in the back of a disciplinary guidelines. Some have incorporated them wholesale. Again, there's a variety of options. And the hard part, I think, for staff is to decide, what should we bring forward? Well, we're bringing you forward all the options, and there are so many. So there's a lot to think about. And what you want the final product in the long run to look like may also inform what we should do now, whether it should be the Band-Aid or maybe a tourniquet, or maybe we should just like wholesale fix the arm here. So,
Dr. Rajo, I want to make sure that we address what you were asking us to address too. Thank you, Sharice. I think that was helpful. Can you tell me exactly what you want us to address that Karen covered?
Oh, well, Karen, you heard her argument that it would be best to bite the bullet and incorporate the model orders along with the uniform standard now, rather than just doing a quick fix. And thinking that makes us clear to the abuser, so to speak, or the licensee who is in this position to have this. How do you look at the fact that that seems a comprehensive approach to doing things, but yet we're up against the wall here with so many other issues? How do you think about what you said?
Well, we've had extensive conversations on this with Karen and with staff, and typically in a situation like this, we're going to bring you. We're going to bring you a very specific recommendation and try to provide that guidance. In this case, it was a little more difficult to do that because we have more than one option. There's different ways of approaching this. I don't want to repeat what Cherise said, but I think that's right on the money. And what Karen said, we can go with a short-term solution and address this at a later time. We are going to look at disciplinary guidelines, or we can just try to go in right now and start working on this model that kind of looks like disciplinary guidelines, provides some clarity, and will take us longer. We probably, the workload issues that Sharice have identified are very real. There's a possibility that this wouldn't be ready by the next board meeting. It relies on us working with enforcement staff. It relies on our own staff. And, as you know, we've got other priorities. So I want to say this, that whatever the reason we're presenting this to the board this way is because we want the board to give us guidance and direction on which way to go. And whatever way the board tells us to do this, we're gonna try to carry it through to the best of our ability, whether it's the dental board model or whether it's the standalone as is uniform standards version that was presented. I hope that's helpful.
Okay, yeah, I think so. But I would like to ask board members how they're thinking about this, how they feel about accepting the Band-Aid approach as opposed to delegating this and having a more incorporated document. I think you've stumped us.
Can you hear me?
Is that Todd?
Yes.
Okay, yeah. Yes, I can hear you.
Okay. I kind of prefer, as what you were saying earlier, Marcia, adopting the uniform standards and looking at the disciplinary components separately. Because I think everyone's going to be interested in, I know I am, is what exactly are those disciplinary components? Do we really want to look at that? Are there some things we want to tighten up and maybe change? And given everything that is facing the board between now and the end of the year, which is only 4 months away, I personally would prefer that particular method.
Okay, thank you. Can we get other board input? Does anyone disagree with that? Debbie?
I'm along the same thoughts as Todd of just getting that part approved now.
Okay, are there any, let's see, Holly?
I would agree with that. I was initially thinking a little more going towards the model, but I'm also thinking about the workload of Sunset. And so I'm weighing more towards what we're talking about, just adopting it as is right now.
Thank you. Karen?
I agree with Holly also. I was actually adopting the uniform standards, and I was actually wanting to go to the way of also going with the adopting what Karen Halbo wanted us to do. But I guess if Sunset is going to be time consuming, then let's just adopt the uniform standards right now, and then we'll talk about the other stuff later.
Okay, thank you. Gilda, do you have we'd like to hear your thoughts.
Yes, I'm back to my original comment, keeping it as efficient as possible, whether that be going with the proposed language and then referencing the separate document. I think that would be efficient, and especially if we have a time frame deadline that's quickly approaching. But otherwise, having further conversation to expand on this task at a later time, but in the immediate, time frame right now, keeping it efficient and addressing what we need to address in a way that's going to be understood by our licensees and giving us guidance as we make decisions.
Okay, thank you. So just to clarify, Heather, that we would be moving to accept the proposed regulatory language for uniform standards as written in the documents, page 1 through 5, for our board. I don't know about the standalone document aspect of that, but can you address if that's what we are would be accepting or be moving?
Correct. To move forward with the discussion you just had, we would need to change in the draft language in section 1399.131.1, where it currently is highlighted standalone document. We would need to change that to say uniform standards regarding substance abusing healing arts licensees, March 2019. And then we would also need to change in section 1399.155.1, where it says standalone document, to change that to read uniform standards regarding substance abusing healing arts licensees, March 2019. So we would need a motion to that effect, and delegating authority to the executive officer to make any other non-substantive changes and move forward with the formal rulemaking process.
Okay, I see several hands up here, though, before we move forward. Todd?
I'm sorry, I could have sworn I took that down. I have the worst trouble lowering that hand. There we go.
We all do. And Holly, too, I guess, took her hand down. Okay, so if I understood you, Heather, we have to first move to accept substituting the standalone document for the uniform standard language that you just referenced. Is that the first motion?
I believe it could be done all as one motion, that you're adopting the regulations as changed to incorporate the uniform standards document.
Okay.
Yeah. And it looks like Karen has her hand up, so she can further clarify.
Okay, Karen, how
Well,
about?
it's a delight to clarify. Heather nailed it. I've had to explain things that the analyst didn't get, but you're just putting the name of the document, which immediately followed your motion language, immediately followed the memo, into the spot where it says standalone document. Instead of that, you have the name of yours, which is the uniform standards regarding substance abuse and healing arts licensees and the March 2019 version. So she's got it perfect. And sometimes people have the analyst read the language of the motion and then the person says, yeah, I adopt that if there's any confusion about the language, but it's important to have that correct for the record.
Okay, thank you. So Heather, would you mind repeating exactly how you'd like this motion to read?
Sure. We would like a motion that the board is adopting the draft proposed regulatory language regarding uniform standards with the change in section 1399.131.1, changing where it currently says standalone document to read uniform standards regarding substance abusing healing arts licensees, March 2019. Also changing in section 1399.155.1, where it currently says standalone document, to read uniform standards regarding substance abusing healing arts licensees, March 2019, and delegating to the executive officer authority to make non-substantive changes and move forward with the formal rulemaking process.
So I'd like to say so moved. Do we have a second?
This is Holly Kaiser. I second.
This is Gilda. I second.
Okay, I think Holly was on there first. Charisse, would you like to? Well, do we need public comment before we go into any votes?
There you go.
You do, Madam Chair. This is Michael.
Okay.
This is the moderator. We've opened the Q&A panel. If you'd like to make a comment on the proposed motion, please click on the Q&A icon on your screen, type comment into the text field, and submit that to our panelists. And seeing no requests, would you like me to close the panel?
Yes, thank you.
It is closed.
Thank you. Is there any further board discussion? Seeing none, Charisse, could you call the vote?
Absolutely. Dr. Raggio,
Aye.
Ms. Kaiser,
Aye.
Mr. Borges,
Aye.
Ms. Chang,
Aye.
Ms. Dominguez,
Aye.
Ms. Snow.
Aye.
Motion carries.
Thank you. We have about 12 minutes before our panel discussion begins on cognitive screening. I'd like to recommend that we take a break at this point and return at 11 o'clock sharp. I'd like to welcome everyone back from our break and welcome our many panelists that we're going to have speaking on our topic today, which you'll find under tab number 13, agenda item number 13, discussion of cognitive screenings and assessments and audiologist scope of practice. Many of you may be familiar with this topic and many of you may not. So I'd like to give a little background about it before we ask our panelists to speak. You may or may not know that over the last many years, there is increasing evidence that's been demonstrating a clear relationship between hearing loss and cognitive decline. Many audiologists work with the elderly who suffer with hearing loss and demonstrate communication difficulty. And sometimes we are often the very first professionals to observe symptoms of cognitive decline in our patients. That is, problems with memory, emotional difficulties, social disengagement, and many other aspects. So this issue for the board arose when a California audiologist approached the board asking if audiologists are allowed to perform cognitive screenings on their patients, primarily for purposes of referral to the appropriate professional who can perform diagnostic evaluations. So in order to do a comprehensive investigation of this issue, the board has invited a number of professionals from the psychology, social work, and audiology communities who can help us understand this issue better, with particular interest in providing information on screening versus diagnostic testing. So I'd like to now introduce the members of our panel, and forgive me if I mispronounce your name, but these are the individuals from the psychology and social work communities. Dr. David Lechuga, Dr. Nancy Bryson Mall, Dr. Mario Espitia, and Dr. James Hiramoto. Audiologist Douglas Beck will be joining us in a few minutes. So if you look under tab 13, you'll see not only the credentials of these individuals, as well as a number of articles that have to do with this topic. So I would like to ask Dr. Lechuga to start us off in this discussion, and then ask our other expert panelists to make their comments following him. Mr. Lechuga, Dr. Lechuga.
Hi, Dave Lechuga. Thank you for having me here. So I'm happy to share some slides here. I understand we just have a short period of time, like 15 minutes or so. Am I able to advance the slides on my own, or will you advance them?
I can actually let you, or I can do it for you, either way.
Okay. How do I advance them?
Let me transfer you the controls to do that.
Excellent. Excellent. Yeah, I'm very mindful. Thank you. And so,
so on the left side of your screen, you'll see a little vertical bar, and at the top of that bar, there'll be 4 squares in a cluster. If you click that, it will give you a thumbnail view, and then you can click through them from there.
Awesome. Awesome. Okay. Well, I want to be mindful of the time and just let you know, I'm a neuropsychologist, and I'm primarily in clinical practice. Also, I do forensic work. And you can read the short sketch here. I won't bore you with all of that, but I was asked to just cover some screening tools here. And let me just kind of highlight some of the things that are important to consider when we do our evaluations in general here. There's 6 different domains, and I won't go into them in great detail, but certainly whenever we screen as neuropsychologists, we are doing some of the things that you're concerned about. So clarifying if someone is presenting with cognitive decline that could be considered consistent with a dementing condition or degenerative disorder versus other conditions. The most common other condition is something like a psychological issue, such as depression. And then we're also asked to characterize what we find cognitively, like what would be the fallout from a particular brain-based abnormality or injury, such as a traumatic brain injury. And then we'll participate in treatment planning. Many of you are on teams wherein you participate in the whole rehabilitation process. We evaluate treatment effects with serial testing. This is something I'll come back to and emphasize because it's important that you use tests, even as screeners, that factor in practice effects because you can introduce confounds or artifact to kind of create spurious findings if someone is too familiar with the exam. And then obviously neuropsychological tests are used for research purposes and then quite frequently in forensic applications. And that's not just in personal injury damages situations, but also in situations wherein there's a question about capacity, capacity to participate in one's defense, for example, in a criminal setting, or capacity to understand what is happening as far as a sentencing phase of a criminal, or in other situations, capacity to actually make a will or to understand the implications of one's decisions when it comes to things like trusts and wills. But we always keep in mind when we do these tests, it's not just a screening or a test. You have to consider who is that individual, obviously, their ethnic background, their culture vis-a-vis being examined, their linguistic background. It's not enough just to give a test. You have to actually think about to what degree has that test been standardized on individuals with this background. And then certainly the settings matter too. Like in an outpatient setting, frequently one is screening, and the screening can be done via tests as well as other approaches, as many as you do. And then also in inpatient settings, there's things to consider when you screen in those settings, like what is that patient's health? And are there other factors that might be affecting their health other than something to do with a brain-based abnormality per se? And then the referral question is really important for us. Why is this being referred, this case being referred? And, if we're not clear about that, it's important to take a step back and to get some clarity, at least as a neuropsychologist. Now, here's the thing that's often the rub. It's difficult to just step forward and do testing, even screening, if one doesn't have the proper training and expertise. And so I just want to highlight what our training is as a psychologist and then subspecialized in neuropsychology. So one needs coursework, usually at the undergraduate and graduate level, in test measurement, statistics, psychological assessment, and then supervision in this whole process, which can occur throughout the mid to latter parts of one's doctoral training and throughout postdoctoral training. And then there's subspecialty training if you do a neuropsychological assessment. In particular, many psychologists do screening, but only those that are trained as neuropsychologists, which is another 2-year postdoctoral fellowship or residency, are competent to do the in-depth neuropsychological assessment these days. And then also the scope of practice may apply, because someone may have this background, but maybe they're more attuned to pediatric issues or lifespan issues that involve older populations. So one has to appreciate what is their own unique training and expertise, and then ethically only function within those bounds. So there are some examples of qualifications that I wanted to give you, and you can click on these various links here. And this is a really good example of the cutting scores, if you will, or the classifications when it comes to who can do what according to a test publisher. And they reference back to the American Psychological Association and other bodies, such as various neuropsychological guilds here. And there's different levels. For example, level A, you don't need any really qualification to give these tests. Usually it's questionnaires. And then level S, you can purchase the level A type tests and S products, but you need a background to practice as a healthcare professional. And then you need to drop down, and this is kind of the thing that sounds maybe interesting to this group, is there needs to be appropriate training, experience to administer, score, and interpret the clinical tools that are being administered. So that has to be part of someone's training. And that training may be pre-credential or degree or post-credential or degree, but that needs to be documented, and then these publishing houses need to see that. For level B, the training in psychology or other healthcare field is important, with coursework in measurement, theory, test interpretation, statistics, etc., and then the appropriate licensure and certification. C would be where I'm at. So that would be, you meet the other criteria, and then you have the advanced training for the interpretation and scoring of all the tests and the appropriate licensure to do so. Okay. So I wanted to give you some ideas of some of the screening measures that we use. First, it's just basic that I think really good clinicians know right away. Like on gross examination, just is this person oriented? This is probably what's being picked up and a concern to clinicians who are screening for things like hearing. But is someone attentive? Are they oriented to their self, the situation, the day, the date, the time, the location? How is their memory, for example? If they can hear you, if they can attend, can they follow a simple direction? That's a combination of attention, receptive language, obviously, and more recent memory. And then what about their processing speed, factoring in age-related issues, and then grossly their vision, you're all experts in hearing, their psychological status, just their overall kind of train of thought and judgment. And then we pay attention to things like their general hygiene, their gait, their ambulation with and without devices, their motor planning. And can they really relate and establish rapport, or is that a struggle for them? And then, of course, it's important to pay attention to cultural and linguistic factors. Like, is this a foreign experience for this individual? Is there a degree of suspicion that they bring into any examination that might affect their willingness to participate in that exam because of past negative experiences or perceptions that something could be used against them, for example? And then, of course, the language too. If someone doesn't have doesn't examine in the language of the patient's choice, then there's always that artifact. And briefly, here are some tools that are helpful. They all have pros and cons, but you'll typically see these tools used in screenings of cognitive status. And again, I have clicks here, hyperlinks, so you can go and take a look at them. The Montreal Cognitive Assessment is in several languages, but it covers some of the brief mental status domains that I've mentioned in a more psychometrically sound manner. And there's cutting scores for these. So if you fall below, for example, a score of 26 on the MoCA, then there's a higher probability that something is awry cognitively and you have to go further. And then there are other measures that are a bit longer. The R bands, or repeatable battery for the neuropsychological assessment, can be done with adolescents and up. And it's a higher qualification level. But the key thing about the R bands and impact, which is computer-based, is that you need certainly the expertise, but these factor in repeat testing. So as I mentioned earlier, you want to have the opportunity to examine someone over a period of time with a similar but different battery, even if it's a screening test, so as not to make the test so familiar to the individual that they're doing better, not because they're better, but because they remember and are familiar with the test. That would be the practice effect. So the practice effect is attenuated when we have serial testing with different versions. And then, let's see where I'm at here. Yeah. And then triaging, typically when we screen in different settings, and we pay attention to some of those gross examination factors, may do a brief assessment. And if we have that concern about cognitive difficulties, we have to take a step back and consider the alternatives. Like, as a neuropsychologist, I have to pay attention to things like, are there vision issues? Are there hearing problems? Are there rapport issues? And some of the other factors related to cultural levels, level of education, linguistic proficiency. And then typically clinicians that do those initial screenings make that referral to either neurology for more in-depth workup, or neuropsychology, or sometimes both, if the resources and the expertise are there. And it's always helpful to find out what happened. So, for example, if you locate or identify an individual that there are concerns with respect to cognitive functioning, maybe mild cognitive impairment, it's always helpful to check back in or to obtain information about the outcome of a referral to a specialist, and see if your idea about what was problematic or worrisome was confirmed or not. So I think the concern for most licensing boards is about ethical practice. One of the areas, scope of expertise, and then ethical practice. So I know as a psychologist, we're always vigilant about, are we functioning within the bounds of our knowledge and expertise based on our training, experience, and professional background in general. And we reference our various codes of conduct and ethical principles for that, as well as our own board, which would be in California, the Board of Psychology. But every state, territory, association, district has some sort of governing body for licensure, at least for psychologists. Okay, so I hope I kind of touched on a few things in there, and that's about all I wanted to share with you. And if there are any questions, then I'm happy to address them.
Sure, the plan is to ask board members to ask questions of each speaker, or should we just move ahead to the next panelist and save our questions for the end before going to public questions?
I think that's completely up to your preference, but it might be helpful to go ahead and get the marriage and family therapists, social workers, and school psychologists input at this point, and then kind of have a whole discussion. Get that, and then have the audiologist perspective, Dr. Bex, and then open it up for discussion.
Okay, sounds good to me.
Okay, did you want me to stay on?
Oh, yes, please.
Yes, if you can, yeah.
Okay, I will. I'll mute.
In no particular order, I do have Dr. Nancy Briesenmall as the potential next speaker. Are you prepared to talk at this point?
Yes.
Please go ahead.
Okay, so I am a licensed marriage and family therapist, also a licensed psychologist. So to echo Dr. Lachuga, not sure of that. We also would need to follow our scope of practice and competence and practice ethically. So that would depend, individually on that therapist's particular training. Our education is very standard, so it would come into play if they've had additional training in assessments. We are all trained to do a basic mental status exam, so he mentioned that in his presentation. That is something that we would be expected to do in our scope, to be doing a mental status exam on patients. And many marriage family therapists have gone on to do additional training so that within their scope of competence, they've been able to add different assessment tools. But again, we would need to follow our ethical guidelines and stay within our scope. Anne, did you want to add anything to that?
No, I think you covered it. In terms of marriage and family therapists and the ability to do psychological tests as part of their assessments, it is something that's defined within the scope of practice as a psychotherapeutic technique. But we do also have an attorney general's opinion that clarifies that. So that information might be helpful to the board.
I don't really have anything further to add, but can certainly answer questions if anyone has any.
Okay, may I ask Dr. Mario Espitia to speak at this point?
Good morning. Thank you for having me today. And I have a PowerPoint that I'd like to share.
I have now made you the presenter.
Okay, let's see. Yes. Wonderful. So my name is Dr. Mario Espitia. I'm also a licensed clinical social worker here in the state of California. And just to give you let you know where I come from, I'm in Los Angeles, and I currently work for National Association of Social Workers California chapter. And prior to coming to NASW California, I was working for Kaiser Permanente as a palliative care and dementia care social worker. And so I did work in a team together with a physician who also specialized in geriatrics. And we worked together to conduct an evaluation when patients were referred because either they or the family members had concerns of memory loss and potential mild cognitive impairment or dementia. And prior to people coming to our clinic, there are certain screening tools that social workers use, as well as physicians, nurses. And this was discussed earlier, but is a patient-oriented at the 4 different levels: person, place, time, and situation. And when a person was referred, it was because there was some concern in one or more of these levels. Another screening tool that social workers in primary care settings or physicians, what they would use is the mini cog. Basically 3 steps, a 3-word registration. They would give the client or the patient 3 words to memorize. They would ask them then step 2 to draw a clock. And then step 3, they would ask the patient to recall those 3 words pretty quick to complete. And this is the scoring for the mini cog. When patients came to our clinic, this was the tool that I would use most of the time, the mini mental state exam, where we would assess for orientation, registration, attention and calculation, recall, language, and we would also ask them to draw a clock. Dr. Lechuga spoke about the MOCA. This was the MOCA, that screening tool that we used sort of on rare occasions. The physician would prefer for the social worker, myself, or the other staff, RN, for example, to do the MOCA if the patient had educational level of master's degree or above. And this one would screen for visual, spatial, executive, naming, memory, attention, language, abstraction, delayed recall, and orientation. As part of my evaluation that I did together with the doctor when I would go in to see the patient and the family members or other loved ones, there were certain information that we would try to gather. If the patient had any concerns, what were their concerns? Important information also gathered from family members and friends. Many times the patients themselves may not be aware of their own memory loss or cognitive decline, so family members and friends were good sources of information. And we would also assess for mental health concerns. Are they also experiencing, could it be that they're experiencing depression, anxiety? We would also gather information on functional status, so activities of daily living, and we would also gather information on instrumental activities of daily living, if they were able to do things in these activities independently, or if they were dependent, and the reasons why they were dependent. And of course, it's important to know then what are the early signs of dementia in order to better guide the conversation with the patients and the family members. These were a lot of what's listed on here were a lot of their concerns. And when we would do the mental health screening, we would use the geriatric depression scale to assess for depression. And if they scored if they answered if they answered and it was a bolded, they would get 1 point. And if they scored 5 or more, then it would suggest depression. And then our next step would be to possibly refer to mental health or behavioral health services for additional assessment. After I completed, after the social worker or the registered nurse would complete our part of the evaluation, we would then share that with the physician, discuss and review the case, the chart, and the physician would take that information and then conduct their part of their evaluation and assessment. And after determining a diagnosis, I would come back as a social worker and provide education on their condition, provide resources to community organizations such as Alzheimer's Association or Alzheimer's Los Angeles here in this area, and any other resources that the patient or the family members would need, caregiver support. Thank you.
Okay, thank you. Can we now hear from Dr. James Hiramoto?
Hello. My background, I'm a school psychologist, and I think maybe more than any of my other colleagues here, I give intelligence tests, cognitive ability tests every day. So, in speaking about cognitive ability tests, an intelligence test, I don't think this is something that you'd be doing as part of your scope in practice. And I know that this is part of, we're talking about screening tools and things like that. And intelligence tests aren't screening tools. So what I think is most important, what's already been discussed, is Dr. Lechuga's talking about repeatability of some of these tests for assessment of cognitive decline. You want to be able to make sure that you're charting where they are and as they go through the process of cognitive decline to dementia, you're charting how their abilities are decreasing. And as Dr. Espita mentioned, family is important because one of the main things is you're not going to know where they started from. So how do you know they're declining? This may be where they've always been. So getting that family background is really important. Speaking as a person whose mother has gone through cognitive decline and now dementia, I can attest to the fact that being able to talk to the family is really important to know where they were. Is this how they were? Have they been like this? How long? Because the family's probably the ones noticing the decline first. But in terms of screening and things like that, as maybe the first person this person's turning to because hearing loss, I think looking at their adaptive behavior might be a good screening process for you. What do you notice about their adaptive behavior? Their as you talk to them, their memory, their language skills. Ask them to read something. Simple math problems. Are they having trouble doing that? Practical knowledge, problem solving. Do you see them having trouble making judgment decisions? Those might be all things that you, as a clinician during your audiology exam, might notice that these are some things that are giving you raising red flags, and that might be a good indicator of maybe making that referral. Instead of trying to do an assessment on one's own. And maybe trying to give another test that maybe you're not familiar with, or a screening tool you may not know its efficacy of very well. Other than that, the lists of tests that are being talked about are all brief screening tools, which help because they're fairly quick to give. Unlike intelligence tests that can take sometimes hours. So, and that's one of the things about I would say the benefit of screening tools too is that they are more easily given and repeatable. And I'll be here if you have any questions for me.
Okay, thank you, Dr. Hiramoto. That was very interesting. I'd like to call on our last speaker, changing the perspective a little bit here, to Dr. Douglas Beck. He is an audiologist and a leading expert in the area of audiologists doing cognitive screenings, has done considerable work in this area, and I'm anxious to hear his thoughts. Dr. Beck?
Okay, thank you. I presume you can hear me, and let me start by thanking you for inviting me. It's an honor to work with this prestigious group. So audiologists in general have a undergraduate degree, a bachelor's in communication disorders and sciences. About 90% of us, 95% of us have that. And then we go on to have a 4-year clinical doctorate. And so the knowledge of communication disorders, language disorders, auditory processing disorders, listening disorders is rather well known to the audiologist. In fact, in 1949, Dr. Michael Bust, which is Myklebust, Dr. Michael Bust in 1949 at the close of World War II, as we're seeing all these veterans with noise-induced hearing loss, started talking about you can't really separate language from listening, from psychology, from auditory processing disorders. These are all intricately interwoven and they intermingle, and each is a very, very significant pathway, but we look at them through different lenses. You know, we might have a psychologist here, we might have an audiologist there, a speech language pathologist somewhere else, and each of us looking at the same patient may come up with a different diagnosis based on our discipline, our areas of expertise. With regard to screenings versus diagnostic testing, audiologists do diagnose across the USA, but we don't get any at all into psychological or psychiatric or any such diagnosis. The argument, if it's an argument, or the discussion, I should say, is more about using screening tests. And here's the reason, I think, in a nutshell. In the USA, you have 325 million people. Of those, 37 to 38 million have hearing loss on an audiogram. Okay, so that's the test most of you are familiar with. There's another 26 million people in the USA who have supra-threshold listening disorders. They may have ADD, ADHD, they may have Alzheimer's, they may have cognitive impairment, they may have MCI, they may have auditory processing disorders, auditory neuropathy spectrum disorder, cochlear synaptopathy, traumatic brain injury, but they won't have hearing loss. However, their primary complaint is often, I can't understand what people are saying, or to make it worse, I can't understand what people are saying in noise. And that's why it overlaps so much with audiology patients who have hearing loss, is because the number one complaint that audiologists get across the USA is the inability to understand speech and noise. So this is very, very similar to a patient who would have as their primary complaint, I can't understand what people are saying, I don't know what he said, I'm not sure that I heard that right. And those were often signs of, you know, as we've been discussing for the last few hours, right, mild cognitive impairment, dementia, cognitive decline, and these are often manifested as speech and noise problems. So the proposal, my personal proposal, would be that because speech and noise, understanding, assigning meaning to speech, assigning meaning to language, assigning meaning to sound, decoding that neural image that's going up your brainstem along the auditory nerve, decoding that appropriately and perfectly is something that audiologists face all the time. So what we'd like to know in patients that we would screen would be, is this in alignment with the audiologic testing and outcomes, or is this patient one of those who has absolutely normal thresholds, they have normal audiologic responses, but they're unable to understand speech and noise? In that case, there's a few things that are already best practices in audiology, of course. I mean, we've been doing this since 1970. Ray Carhart proposed that every time you do a hearing test, you should be doing a speech and noise test, because that stresses the auditory system. And that's a very, very important thing to do, because that's how you're going to find those other 26 million. Now, if they do poorly on a speech and noise test, it would make good sense to go ahead and do a cognitive screening, because then if basically they just need an improvement in speech and noise, well, the audiologist can handle that. However, if they also don't do well on a cognitive screening, such as the MOCA, the mini mental state exam, the CogniView, the mini-cog, if they're not doing well there, they don't pass normative guidelines on those, then simply the audiologist would refer to whomever is the appropriate professional for that patient in that situation. That's going to vary based on insurance, based on, is it a medical center, is it a private patient, where does their insurance say they must go, must they be referred, are they in an HMO, a PPO, all these things. But the point is, if we know that somebody has failed a cognitive screening, then that helps us to understand a couple of things. Number one is it could be the source of their speech and noise problem. Number two, we want to refer to a mental health professional, which would not be another audiologist. And number three, it may be appropriate to refer to a psychologist, a neuropsychologist, a GP, an internal medicine family practice. It just depends on the patient's situation. And we can't, I think it would be very disingenuous of us to write a rule that, oh, we should refer all these to psychology, because that would be like referring all of them to a GP or anywhere else. It's just, there's so many individual scenarios. We have to be respectful of that and just realize we did a screening. If it's passed, then great. If it's failed, refer to the appropriate person. And it's very hard to write a guideline for that, because it's going to vary with with every patient you see. I totally agree with what we've heard earlier today. Audiology certainly is bound by codes of conduct and codes of ethics. And again, we're only talking about screening. We're not talking about doing intelligence tests. And of course, anybody who goes into any of this has to have appropriate training and knowledge. I'll give you, for an example, school nurses test hearing all the time. Well, my sister's been a school nurse. She's been a registered nurse for 55 years. And, she's the first one to tell you, I'm not really that good at that hearing screening thingy. And that's okay. She admits it, so she avoids it, right? Everybody should only act within their area of expertise, their area of knowledge, and of course within their scope of practice. These aren't debatable topics in my mind. These are all straightforward. This is what we do and how we do it every single day. So the goal is, because so many of these patients are going to overlap with typical audiology patients who might have hearing or listening disorders, it's very important for the audiologist and for patient-centered care to identify which patient you're dealing with so you can refer them down the right pathway. And again, that could be a PCP, a GP, a psychologist, neuropsychologist, whoever the most appropriate referral is in that scenario. Just by way of repeat, again, 37 million people in the USA with hearing loss on an audiogram, but another 26 million who have no hearing loss but absolutely have supra-threshold listening disorders. And if you want references on those, I'm happy to supply them, but that's a peer-reviewed paper that I wrote with Dr. Jeff Danhauer in the Journal of Otolaryngology and ENT Research. So our goal is to identify which patient is which. That way we can get them onto the right care that they need. Dr. Arlene Petranton is still the executive director of ASHA for the last 17 years, and I just published a interview with her at the hearingreview.com. And she points out, she is a clinical psychologist, by the way, and she points out that often people with cognitive disorders, dementia, have the exact same complaint as people with hearing loss, the inability to understand speech and noise. So I asked her in that interview, which is published in hearingreview.com, do you think that audiologists and speech-language pathologists should be doing cognitive screenings? And she said, yes, it's part of a holistic approach to patient-centered care. And so, ASHA has been saying this since 2018. In fact, if you go to their scope of practice in audiology 2018, it says additional screening measures of mental health and cognitive impairment should be used to assess, treat, and refer. And again, cognitive screening, that's going to be a referral, not a treat situation. I also want to point out, I started my career 40 years ago here in California, and I was at the House Ear Institute. Well, we were, just for those of you who are not familiar with cochlear implants, a lot of the reason we have cochlear implants is because of Dr. Bill House at the House Ear Institute. First cochlear implant in the history of the world. I'll give you no, that wasn't it. It was in 1959. And in 1961, Dr. Bill House did 3 of them at the House Ear Institute in Los Angeles. So fast forward 25 years, the FDA approves it in 1986 for adults and 1990 for children. So it took 25 years, and that's fine. That's not my issue. My issue is that when we're looking at can we do a better job, we have to look long term. These things aren't going to be fast. I think that when we have people who have cognitive disorders, when they have dementia, when they have mild cognitive impairment, the first thing that we should be on our mind is early identification. When you look at the Lancet studies that just came out in 2020, Dr. Livingston and colleagues, they said this. They said 60% of your cognitive decline, of your risk of dementia, 60% is due to deoxyribonucleic acids, which you know better as DNA. But they did say 8.2% of your risk of dementia is based on hearing loss. And that is a modifiable risk factor. They named 12 risk factors in the 2020 paper. And the largest of all of them is hearing loss. So my point is these things overlap a lot. And it's important for the audiologist, for me as a doctor, to be able to know which patient I'm dealing with so I can either take care of them or refer them for care to the appropriate professional. Going back to the House Ear Institute in the early 80s, long before it was the cochlear implant was approved, I was doing visual screenings because we knew very, very well back then that in order for a patient to maximize their ability to understand with a cochlear implant, they had to be able to synthesize their visual image and their auditory image. The visual image is quite redundant, and it's very, very useful as far as speech reading. So before we would consider somebody for a cochlear implant, before we would consider them as a cochlear implant candidate, we did a Wechsler intelligence exam, and we also did visual screenings, which, you know, and the Wechsler was done by Dr. Wechsler, by the way. But these were all part of our pre-implant approvals because we knew how important it was to have that redundant information. But my point on that is I was the one who did all those visual screenings on literally hundreds of patients. And I didn't feel it was out of my scope of practice at all. I was using it as an audiologist to supplement the patient's ability to understand speech and noise. So in order to do that, I had to assess with a Snell and eye chart back in the day, you know, could they see clearly and could they make sense of what they were seeing? And if the answer was no, guess what we did? Of course, we referred to optometry or ophthalmology. There are many states who've already looked at this. I applaud California for looking at this very seriously. I think it's due. I think it's the right thing to do. I know states like Arizona, Arkansas, Colorado, Florida, Hawaii, Kentucky, Rhode Island, Vermont, West Virginia have all looked at this and come with the conclusion, as best I'm aware, that yes, it's within scope of practice as long as you're not charging, as long as you are screening, as long as you are not diagnosing, because it's facilitating getting the patient to the right professional. We talked about ASHA, we talked about lots of things. And I think that this is great. I'm so glad to be invited to participate in this. I'm happy to stick around and answer some questions if there are any. And with that, I think I will turn my time back over to the group.
Okay, thank you, Dr. Beck. That was very informative, and thank all of the panelists for their input on this topic. I'd like to now ask if there are any board members who have questions of our panelists. We can use the hand raise function if you would. Looks like you did such a good job that we don't have any questions, except for I do. I'm just wondering if the feeling generally among the social workers, psychologists on this panel, that screening is not an activity that requires licensure. Is that a fair statement?
This is Dave Lechuga. I think it goes back to what's the training to do the screening. So it's the illusion is that if you just give a screening tool, that's sufficient. But as you saw, the tools listed so far are in English. They can be in Spanish, but I think someone has to have some background about the merits of the tool. It's a blunt instrument. So does a person have the right educational background? Do they have the right linguistic background? Is the tool assessed in a manner that is standardized versus not? What are the normative bases for the tool? Because there's a lot of false positives. Like I just heard something about the MOCA only being used for graduate students and above. That's incorrect. That's incorrect. That's used for lower levels of education. So that's exactly the kind of knowledge that has to be, taken into consideration, or else you're going to have false positives. So you find somebody that you think has these areas of difficulty, but in fact they do not. And obviously, so someone just has to understand the merit. And I think if you're going to use a tool, then you should understand the pluses and minuses of the tool, and that might require some additional expertise or training, in my opinion.
Yeah, if I could weigh in on that, I would agree entirely. And I don't think anybody, I know literally dozens of audiologists who do the MOCA. They've taken the training. I know a lot of folks who started with the MMSE, went to the MOCA. I know lots of people now using the CogniView. They all take training. No, I don't know of any audiologist who would take this lightly and just, oh, here's a tool, let's apply it. It's the same as any other clinical tool, and I think the point is very well taken. You have to be trained. You have to operate within your knowledge base. You have to refer when you don't know, and you have to act professionally. There's no discussion or debate on that. I mean, the only people who should be doing screenings are people who've been trained to do that. And I would go further, and I would say my biggest fear is not false positives, it's false negatives.
Dr. Beck, do you have any sense of how many audiologists out there are actually performing this type of screening? Any idea?
I can tell you that I haven't seen a quantity. I haven't seen anybody count them. I do know that if I were to guess, I would probably say that between 250 and 500, and I'm pulling that out of the air, but just based on the lectures that I give, the the publications that I've published in the last 10 or 12 years on this and the feedback I get from audiences, I would say there's probably, and again, I'm pulling it out of the air, I have no data to support this, but at least 250 and perhaps up to 500, maybe a few more. That's what it looks like from my angle.
I believe that more and more audiologists are being encouraged to do cognitive screenings as part of their patient care. And I don't know if we can say for sure that all of them seek appropriate training. Would you say that's not the case, that you're convinced that all of them do?
Yes, these are all licensed healthcare providers. These aren't, people who have no knowledge of scope of practice or ethics, and they all have scope of practice and ethics responsibilities to their state, to their patients, and to their national organizations. So we have lots of things that are included in our best practice guidelines, for instance, by the American Speech Language Hearing Association, by the American Academy of Audiology. And as a quick example, because I know our time is limited, speech and noise testing, probably the majority of audiologists don't do that in their daily clinical life, but it is a part of best practices. So when you're doing that, of course, you have to learn to do it appropriately. You can't just do it because you're an audiologist. And it's the same that we say in medicine. You don't practice to your full scope of practice. You practice to your scope of practice within your areas of competency. And I'm not aware of anybody who would volitionally or accidentally violate that, because this is an area that one needs to study and be knowledgeable of in order to do it well and to do it putting the patient's best interest forward.
Okay, thank you. Can I ask if there are any screening tools that any of the psychology or social work panelists would feel audiologists should avoid for one reason or another?
Again, Dave Lechuga, I would avoid things like the R bands, the things that require just a little bit higher. That's why I gave those qualification levels, because I think this has been really thought through by test publishers. So anything that requires advanced training and expertise, I would avoid. Those are laid out whenever you purchase these tests.
Dr. Lechuga, did you say earlier that an individual who purchases one of these tests, the manufacturer will have to verify their credentials before they sell it to them, or is it just anybody who seeks it?
You have to attest to having certain background, expertise, and training in order to use the tests, particularly if they're purchased from a test publisher. Now, tests may be laying around clinics and things and kind of just are picked up and used, but this is one of the choke points, if you will, where you make sure that the person who is purchasing the test has a certain background and understands the psychometrics of the test. It gets back to, yes, false positive, false negatives, but the basic point is the increased risk of inaccurate data, which has huge ramifications potentially for a patient and their families. So not any tool should be used by anybody, but there are some screening tools that can be used by professionals that don't have the advanced training and expertise. And again, those are listed under the different qualification levels of every test publisher.
I'd like to ask all of the panelists how you approach, telling someone that you want to do cognitive screening, let alone doing it and telling them the results, can be a very sensitive topic. And I'm just wondering if you can speak to how you approach that idea that you're going to say, gee, I think I should do a cognitive screening with you, and these are the results. Can somebody speak to that? How you approach it?
Yeah, I'm happy to give you a brief overview on that. I wrote a paper with Dr. Michael Harvey and Dr. Barbara Weinstein. Dr. Harvey's a clinical psychologist. Dr. Weinstein's faculty at City University of New York. She's a professor of audiology there. And what we said, we wrote a few papers together, some on dementia, some on cognitive decline. And we said, it's very important to not hold yourself up as a psychologist or a social worker or a psychiatrist. What you need to do, if you're curious about these types of screenings when discussing it with a patient, is you would not say, I'm going to do a cognitive screening per se, because I think that those are words you can't undo. And if you say we're going to do a cognitive screening and then you tell the patient, well, you didn't pass or you failed, those can potentially be very, very damaging words to the patient's psyche and to their emotional well-being. And so we don't approach it quite like that. We take a different view, and this is very common among the audiologists I'm familiar with who do cognitive screenings. is to say, I want to get a better understanding of how your brain responds to words and to images and to sound. So we're going to do this test. And the answer is always something along the lines of, okay, that's great. Thank you very much. Oh, how did I do? Oh, you did fine. But if they fail, that's when you're going to send a note to their physician or whoever the referral might be. And you might say something like, thank you for referring Mrs. Smith. As you know, she's 78 years of age. She complained about speech and noise. Her speech and noise results were consistent with her hearing loss. However, she's, experiencing much more difficult situations. Therefore, we also did a cognitive screening. She did not pass, and therefore we're referring back to you for further guidance on this issue. So we don't, I don't, and the people I've authored papers with, we don't recommend telling patients that we're doing in particular a cognitive screening, and we certainly would not tell somebody that they have failed a cognitive screening. And that's situational. I mean, there are times when maybe I would say that to the spouse or the mom or the dad or the grandson of it. But in general, we don't want to hold that up as our area of expertise. That's an area of inquiry, and it's something that we're working to define, what's in their best interest. So I don't think that most audiologists would ever tell a patient you failed a cognitive screening. I think that's potentially very damaging, and they're not prepared to handle that. I can see doing it, and I can see referring, but sharing the results, I think that should only be done with the other professionals, because they know best how to interpret that and how to manage that with the patient.
Thank you. Are there any other panelists who have thoughts on that aspect? Okay, seeing none,
Can I just interject? I just want to make sure my other colleagues had a chance to say something, but I think you have to circle back to the concept of informed consent for a particular procedure. And I would consider screening a procedure. And so the difficult path here is, does that person have really the capacity to understand what you're about to do with them? That you're going to evaluate them and understand a little bit more about their cognition. I think you can do that, but there has to be some degree of informing and obtaining consent if consent is feasible. Now, obviously, if someone doesn't have the capacity to form consent, then we take other routes like we do in other procedures, speak to family members. But this is a procedure, and I would not take it too lightly. Say you have to have an informed consent. I wouldn't cloud it. I wouldn't sink it into something else. I wouldn't dance around it. I would talk about what you're interested in and why there's a concern. Because if you have findings, then you're then burdened with the information and thinking through, is that information accurate? Is there any potential harm that could come to that patient? These are all the things that have to be really thought through. So it's just my comments.
No, those are great comments, and I basically agree with everything you just said. But when you're doing screenings, I'm not, whether that's a procedure or not. To me, screening is an inquiry, not necessarily a procedure, but that's a matter of definition and state law and those issues. And my point, and I hope it's the one that you heard, is that you have to be extremely careful. I don't want to see people taking cavalier attitudes and just willy-nilly saying, oh, you failed, or oh, you did great, oh, your brain is normal. I mean, all of that's inappropriate. It has to be said in the right way, through the right professions, and with the right knowledge base. And so I would be very careful what I say to a patient, because once you say something to a patient, you can't unsay it.
And in my experience, when patients would come to our clinic for further evaluation, most of the time they knew already the reason for coming to our clinic. The family members definitely knew. I would provide them with an overview of the process and what we would be doing during our time. I wouldn't be the one to provide a diagnosis. That would be the physician, but I would come in after to allow the patient, or in many cases, the family members, to process their thoughts and their feelings about the diagnosis, and to give them a space to ask questions. If I'm able to answer them, I would. If not, I would pass those questions over to the physician for additional answers.
Thank you. Are there other panelists who would like to make some comments? Holly? Yeah, we'll go to board members in a moment. Are there any other panelists, though, who want to make a comment? I want to give everybody a chance to speak if they wish. Not seeing any, I would like to open it up to the board members for any questions they may have or comments. Holly, did you have your hand up?
I think Karen was first. I see your hand.
Oh, okay, thank you, Holly. I just have a question about training. I know, Ms. Dr. Beck, you spoke about how audiologists receive training, whoever do these cognitive screenings. What type of training is involved? Like, is it during the conferences where they have a class or two, or is it actually when they go through their doctoral program?
No, the training is, for instance, if we're talking about the MOCA, you know, they offer training, and the training is offered online, and you can seek it in various sites, and you have to get, I think you still have to get a certificate saying you've been trained to do that. With the CogniView, you know, that was FDA approved, and there's a new peer-reviewed paper that came out about 6 or 7 weeks ago showing the scores on the CogniView ran very much in parallel with the scores on the MOCA, and I'm quite sure that anybody who is doing the CogniView would take the training course that teaches them how to do that and how to use that information. So, I don't really know anybody doing the MMSE in audiology at this point. Many people used to do that 10, 12 years ago, but there's a licensing fee, I think, that goes along with every test. So I think that's been falling out of favor a little bit. The mini cog is one that I've written about, and you know, we recommend obviously that when people are going to use the mini cog, they have to. There's many articles that one might consider reading on that, but I don't know of the formal training protocol for the mini cog. But you know, I think we have to keep in mind that when we're advocating or not for a screener, the interpretation of the results is not necessarily consistent with the diagnosis. And, you know, if you really want to do a good job with these screening tests, you know, the best thing you can do is probably get a PhD in clinical psych or related fields. What we're trying to do is get the patients to the right office. And I think we have to stay focused on that. You need training to use any tool whatsoever in audiology, whether it's a tympanogram, whether it's acoustic reflexes, whether it's otoacoustic emissions. I've never seen anybody just buy it and do it. I mean, you always take a training course to learn how to use that tool. And the training courses will vary based on what the tool is, where you got it, and you know, the expertise of the person who you're acquiring that from. So I think training is indisputably important, and it'll vary with the individual, with their knowledge, with the route of acquisition of the tool, and what the outcome is. The outcome, I think, in audiology is very straightforward, is to say the patient's problems are consistent with an audiologic diagnosis, or I'm finding other indications that I should refer this patient.
I don't see any other hands up. Are there any other board members who'd like to ask?
Sorry, I didn't mean to lower my hand. Yes, this is Holly. I actually on the same wavelength as Karen because I wanted to ask about training, but my question is more about the not training to a specific screening tool, but since ASHA has included this as scope of practice since 2018, is cognitive screening addressed as part of the training, you know, at the undergrad, graduate, doctoral level in audiology?
Right. Well, there are 75 or so different clinical doctoral programs in the USA in audiology, and often these are covered. You know, there's not it's like medical school where everything is not laid out step by step as far as the curriculum taught in each school. You know, there are core courses that everybody gets, and then there's variations. And when we say 2018, that's when ASHA clarified it. ASHA has had a statement that it was consistent, the screening tests for neurological and cognitive abilities were consistent for at least the last 35 years. The 2018 was more of a clarification of that than the first time they delved into that. So it does vary. I can tell you that I teach a lot at universities across America, and we often go into detail on these issues. Yes, we do. But again, I wouldn't promise that every single school offers the same level. A good example of that, I've written a lot on electroneuronography, intraoperative cranial nerve monitoring, things like that, which I spent many, many years in the operating room. And that's certainly not something that is taught by every audiology program. It depends on who is on the faculty there and what the needs of the students are. And so I would consider myself an expert in intraoperative cranial nerve monitoring. I've written books on that. I've lectured on that extensively, but it's certainly not something that every audiologist can or should do. However, they could get trained in it if they were interested, because neurophysiology is a part of audiology. And so, it's an area of expertise that not everybody shares, that not everybody learns. But again, it gets back to something we talked about earlier, that you practice within your scope of practice, of course, by your state and by your national associations, but also within your area of expertise. For instance, I would never do pediatric audiology. I am not that patient, and I love my kids, but I don't know how I feel about everybody else's kids, that sort of thing. And that was a joke. But you know what I mean. I'm not an expert in pediatric audiology, even though, of course, I'm licensed to do that. Everybody in audiology does not do cochlear implants. People who are interested in cochlear implants get advanced knowledge in that before they touch a cochlear implant patient. And again, this comes down to, we have ethical guidelines. This isn't one and done. This is a very, very serious 75-year-old profession, and people do take their scopes of practice and their ethical responsibilities and obligations very seriously.
Can I just ask of the speech pathology board members, my understanding is that training in cognitive screening is actually a part of the scope of practice of speech pathology. I presume graduate students. Is that the case? How long has that been the case? Are you have any concerns about licensure specifically covering that for speech pathologists?
I could give a quick answer, and I'd love to hear Gilda. But part of our scope of practice is, in terms of cognition, is looking at attention, memory, problem solving, executive functioning. And as long as I've been in practice, I mean, I don't even know when that would have been added. I just think that's been there for such a long time. I have relatively no experience working with the adult population, so I don't want to speak to that aspect.
Yes, it's definitely within our scope of practice, working with the adult population with various diagnoses, assessing, memory, problem solving, and similar to what was mentioned just now, but executive functioning. Those are all things that we are trained in at all levels of our education.
Do you use any of the screening tools that were mentioned today?
Yes, we actually do use the MOCA in our practice right now in our acute care setting. Everyone is trained. We document competency for use and for scoring, and we do expect all of our speech pathologists to incorporate some type of cognitive screening or assessment when they are following through with the speech language cognitive assessment that has been ordered by a physician.
Thank you. Karen, did you have another question, or your hands? Okay. Okay, are there any other board comments or questions at this point? If not, I would like to ask for any public comment on this topic.
This is the moderator. We've opened the Q&A panel. If you'd like to make a comment on this item, please click on the Q&A icon on your screen, type comment into the text field, and submit that to our panelists. And not seeing any requests for comment, would you like me to close the panel?
Yes, thank you.
It is closed.
Okay, I would like to make a final kind of conclusionary statement here, if I could, about the audiology scope of practice language in our business and professions codes. And according to the B&P code 2530.2K, the practice language for audiology is actually silent on the issue of cognitive screenings. If we wanted to add language to this statute that specifies that audiologists can perform cognitive screenings, legislation would be required. Thus, with the current statutory language, the board is actually not able to make a pronouncement about this issue. The practice of audiology does not comment on whether it's necessary to have a license to perform screening tasks. In fact, it appears that anyone, even non-healthcare professionals with the appropriate ethical approach, can perform screening tasks. So it doesn't require a license to perform cognitive screenings, and the board really has no authority to apply any kind of restriction or lack thereof regarding this particular activity. Having said that, are there any further questions or concerns? Not seeing any, I would say I'm glad that we finally were able to discuss this topic in the depth and breadth that we have today. I appreciate the panelists very much for their input, their expertise on this. It will help move our profession forward with this information. So thank you again. We are after the noon hour, and I would like to propose that we take a break for an hour for lunch. If anybody has any contention about that, let me know. So we would return about 1:15.